learned senior advocate appearing for the applicant in CAN 3 of 2025 submits that that pursuant to the directions pursuant to the directions passed by the AA's court, the trial court has passed orders which has prejudiced the applicant. To that effect, learned advocate has drawn the attention of the AA's court to the orders dated 31 2025, 31 1 2025, 1 2 2025, 4 2 2025. ওই পর্যন্ত চলে গেছে
Please.
চারটে কোর্টে একসাথে
Please. Bas.
হ্যাঁ, কি বললাম?
I missed him.
By referring to the said orders, what was tried to be impressed upon the is court that the said orders have been passed in gross violation of the present in BNSS, and the same is because of the directions passed by this court on 28 1 2025. Full stop. Uh, According to the applicant, there are 15,000 documents which are to be gone into, and even the Central Bureau of Investigation, or for that purposes, the prosecuting agency was not prepared, which would be reflected from the order passed by the learned special court, that initially only 70% of the copies were supplied. Later on,
No, it's not correct, but only 2 days.
No, that's
38,
record
70
order.
Pass the rest 30%.
and the is 30%
On the next day. What
of
is
the
it?
document. This is submission. I can't prevent him, sir.
No, but
This
I'm
is
sorry,
from the
but it's a
record. It's recorded
This
in the
is
order.
from the
Record. It's not mine.
And
That's
it's
what they
your
have done.
submission also, right?
70% past, rest.
ঠিক আছে, ঠিক আছে, ঠিক আছে।
25,000 pages.
He's appearing in all the forums.
Hey, I
That-
can't.
I don't say that you can't. You will know.
মামলা ছেড়ে দেবো।
Huh? On one day and later on the next day, 30% of the documents were submitted. Full stop.
We have
Full
taken
stop.
documents together.
By referring to different provisions of the BNSS, learned advocate try to impress that the period referred to by this court has been construed in a different manner by the learned special court, and the interpretation made by the learned special court is reflected in the in its orders itself. By relying on the judgment end on of Budhya Swain and others versus Gopinath Dev and others, reported in 1994, 1999 for SCE 396. Learned advocate submits that it would be it is permissible by the for the same court to recall its own order without referring the party for any appeal or revision. Full stop. अच्छा. Reliance was made was made in paragraph 8 of the state judgment, which is set out as follows. ठीक है sir. Okay. Mr. Bhattacharya learned advocate appearing on behalf of the applicant and Shondip Ghosh has also prayed for recalling, modifying, varying, rescinding the order dated January 28, 2025. Learned advocate has submitted that since the consequence of the order dated January 28, 2025 is touching the provisions of the BNSS, thereby denying the opportunity of free trial, a fair trial to the applicant and or the accused persons. The said order is required to be recalled and or varied, resign and or varied. Full stop. It. Hmm. अच्छा. Learned advocate has referred to paragraphs 55 and paragraph 77 in of the judgment of the Honorable Supreme Court passed in A.R. Antule versus R.S. Naik. That's of 1988.
Well, it's 1980, 84, 88 to SCC,
88.
page 602. But it's para 57, not 55. Para 57
57.
and 70. I'm obliged.
The relevant paragraphs relied upon by the learned advocate for the applicant is set out as follows. Full stop. An accommodation has been in play. Next, an accommodation has been in play for on behalf of the learned advocate appearing on behalf of the petitioner. Full stop. Okay. You are Mr. Chakraborty, you are taking the same contentions in respect of Mr. Bhattacharya also.
Yes, yes.
Huh?
Only thing, my lord, the judgment which has been referred to, and I also referred to, is that was a judgment between the contesting parties. And it is repeatedly being submitted before your lordship that we are necessary party. Now the CBI, after appointment of the CBI, these persons were arrested. So they were nowhere either in this writ petition or earlier a necessary party. Now they are coming up against the order passed by the learned special court. Whether this is to be entertained,
अच्छा
the other remedy is available.
কি বললাম
And when his client already filed Mr. Bhattacharya's client, this is application.
without prejudice. अच्छा, and it was submitted by the advocate on record that ये earlier an application for addition of party was preferred on behalf of the present applicant which was dismissed by the court. Present applicant and Shomdeep Ghosh বলবেন, হ্যাঁ? Which was dismissed by the court. ঠিক আছে, full stop. The genesis of the writ petition was in respect of certain complaints made by an individual wherein the complaints were not addressed properly by the police authority is, and as such, a coordinate bench of this court was pleased to বললাম এখানটা এখানটা কি বললাম এখানটা made by one Akhtar Ali relating to corruption. Uh, to transfer the investigation to the CBI. There was initially a seat which was formed, which was and a case which was which case was transferred to the CBI. Full stop. তো যাই হোক ওগুলো আমার হাতে বাইরে যে হয়ে গেছে। আচ্ছা কি এলো আচ্ছা তারপরে এলো আমার কাছে তারপরে
When initially I filed CAN 1, my lord.
আচ্ছা that was the আচ্ছা
The person who's filing it.
so you also preferred before the Supreme Court also.
But against that order, CAN 1 rejection.
I have nothing. I have nothing.
হ্যাঁ
I have nothing.
এই
The
ঠিক
Supreme-
জায়গায়
but
support না
since
করতে-
your lordship has raised this, my lord, Supreme Court said, according to the High Court, there is a correlation between two cases. On that ground, my lord, it was not entertained. Now, in the charge sheet, this is non-auditive document. They have added the charge sheet of another case.
ভালো করেছে। আচ্ছা যাই হোক the petitioner the applicant in CN2 of 2025 referred the challenge say aid order কবেকার অর্ডারটা মমতাজ সাহেবের 23/8 না কবেকার অর্ডার না এটা this 23/8 so challenge the said order dated 23/8/2024 that was challenged before the Supreme Court before the Honorable Supreme Court of India which was dismissed full stop আচ্ছা full stop the writ petition in fact the petitioner on that date was wanting this writ petition for pending Mr. Chakraborty the petitioner was interested in keeping the writ petition pending wasn't it that
Yes, Mr. Tewari submitted.
Both of them do happen or not?
হ্যাঁ কি বলছি? Cool, Shab. I've considered the submissions. Particularly after the order was passed on 28/1/2025 by the AS Court, directing the special court to proceed in terms of the directions passed therein. Acha. What has been brought to the notice of the AS Court today by way of the recalling application and is in respect of the subsequent orders passed by the learned special court. Uh, the subsequent development before the learned aid special court are judicial orders. Now, the said judicial orders cannot be interfered with as there has been a change in nature and a change in the stage of the proceedings. In fact, attention of the court was drawn to the order taking cognizance, the supply of copies, as well as the applications for discharge preferred before the court, before the learned special court. Full stop. What has been tried to be canvassed and impressed upon the court is regarding the nature of the orders passed, the paucity of time, and the voluminous documents referred to therein. Acha. This court has given a specific guideline considering the delay which has occurred, as it was specifically and consciously stated in the order dated 28/1/2025 that if a charge sheet is submitted on November 2025, there is no reason to take 2 more months' time for granting sanction order. Having regard to the judgments referred to by both the applicants, I am of the view that the stress on the merits of the judicial orders cannot be gone into by this court in the realm of exercising the powers under Article 226 of the Constitution of India. The powers of superintendence under Article 226 of the Constitution of India, the 227 of the Constitution of India, and the exercise of this jurisdiction under Article 226 of Constitution of India are two different aspects. What has been in you are for any party over here? State has got nothing to say right now.
Ask me questions on the sanction order.
I'm not.
Will your lordship like to have the citation of that CAN application is not maintainable in the read petition been disposed of? Brahmdat Sharma.
Yes, yes. Please.
Well, the citation is AIR 1987 SC 943.
Yes.
AIR 1987 SC 943. The cause title would be, my lord, State of UP versus Brahmdat Sharma. That was the mother judgment, and lastly, I found Delhi High Court judgment was there, relying on that. That is 2006 Criminal Law Journal 166.
That's a mother judgment.
Yeah, yes, Brahmdat Sharma is the mother judgment, my lord. On
Okay.
this.
Yes. Why should you wait? I don't understand. Acha. In fact, paragraph, acha, in fact, paragraph, acha, the Honorable Supreme Court in Radhesham and Nada versus Shabinath, CHHABINATH and others, reported in 2015, 5 SCCE 423E has been pleased to hold where appeal and revision in a statute is available, the judicial orders as such cannot by way of writ under Article 226 or under Article 32 can be entertained. Acha. Acha, this is this has relevance. This has relevance because of the fact that the learned advocates appearing for the applicants have repeatedly drawn the attention of the court to the orders passed by the learned special court. Full stop. Such orders cannot be interfered either either by way of invoking the powers of this court under Article 220A6 of the Constitution of India, or by way of a recalling application. Full stop. In view of the aforesaid, I'm not inclined to entertain the prayers at advanced. Accordingly, CAN 2 of 2025 and CAN 3 of 2025 is dismissed.
On the basis of the gist of the.
Well, deeply obliged.
Clear that your lordship would kindly direct that this order to be uploaded. That this actually gives us the right. What your lordship has done is your lordship has opened another avenue for us. Your lordship would kindly.
Got the liberty to act on the gist of the order, my lord.
I'm trying to see. We'll try 8:30. See the website.
Most of it, most of it.
And I think that disposed of so. Dismissed.
Well,
Your
dispo-
lordship is disposed or dismissed?
Dismissed.
Lordship would.
No, no.
Sorry.
Dispose will be you will not get a wider door open.
I understand. Dismissed.
road is agile for me.